Good afternoon. Can you hear me all right back there? I'm Sheldon Nahmod, and I'm going to provide you with a primer on the First Amendment. I can't help, as a law professor, but notice that everybody here is a backbencher. You're all afraid that I'm going to call on you Socratically. I promise I will not. I will not do that. The First Amendment really reflects a balance that the framers struck between liberty and order, and that's particularly important for purposes of the overall subject of political protests, which, like the free press, are, in my view, the lifeblood of democracy. In order to give you this overview of the First Amendment, we're going to have to do a little bit of theory and a little bit of history, as well as delve into some practical considerations. So here we go with some preliminary observations. First, even though the First Amendment, which I've set out for you in my outline, refers to Congress, I think everybody here knows, or should know, that states and local governments are also covered by the First Amendment through a process called incorporation through the 14th Amendment. In contrast, the First Amendment does not apply to regulation by private parties. If one of you were to try to punch me in the mouth now because of what I'm saying, you would not be violating my First Amendment rights as such. It's only when government gets involved.
I'll protect you if somebody tries.
Thank you. I'll need all the help I can get, but I do run. I run very fast. Second, despite the no law language in the First Amendment, the First Amendment is not an absolute, as we will see. In fact, and this is something that many laymen do not know or understand, there are no absolute constitutional rights, whether it's the First Amendment, the Second Amendment, the Fourth Amendment, and the like. Third, the First Amendment historically covers speech, oral, the written word, demonstrations, and petitions that are addressed to government as well, and an overall purpose, we'll delve into this in a little more detail, is that we are to educate ourselves about important issues, and we are also to inform government about our concerns, the petition clause. Fourth, interestingly enough, even though the First Amendment is in our Bill of Rights, First Amendment jurisprudence began in the 20th century in the Supreme Court. It is virtually all judge-made law. Fifth, and finally, with respect to the preliminary comments, like every constitutional right, the First Amendment has costs. There are people who are benefited by the exercise of First Amendment rights, and there are people who are disadvantaged, burdened, hurt by the exercise of First Amendment rights. Now into the major theories of the First Amendment. And I want to emphasize that these theories are not exclusive, because really in First Amendment jurisprudence there is a blend of these theories of the First Amendment. But what these theories have in common is that they all stem from the Enlightenment, like our Constitution as a whole. The First Amendment has Enlightenment origins based upon the individual and based upon the assumption of the power of reason to persuade. Not that there is no emotion there, but the power of reason ultimately to persuade. The marketplace of ideas, the one that we've heard so much about. John Stuart Mill and Oliver Wendell Holmes effectively gave us that theory of the First Amendment. And when you think about it, it's pretty clearly based upon the scientific model of experimentation. Namely, the best test of truth is in the marketplace. And we'll see how the marketplace deals with different ideas. And in this marketplace of ideas, government keeps its hands off it is neutral with respect to the value of these ideas. To put it another way, we are all in the marketplace of ideas as willing sellers and willing buyers, and all ideas have potential value. Interesting question that we don't get into, I don't get into today. Is the marketplace of ideas fair? After all, most of us don't own newspapers. Most of us don't own social media. Most of us don't own radio and television stations. So certain groups, certain individuals, certain companies have greater access to the marketplace of ideas. And also, in all fairness, certain ideas take a long time for their truth to be understood. Sometimes falsity goes a long way for a long time, and I think about Nazi doctrine, for example. It took quite a while for the marketplace to extinguish Nazi doctrine. So that's one major theory, the marketplace of ideas. Another major theory is self-government. I adverted to that earlier. The First Amendment is there for us because we need to educate ourselves and others for self-government. This theory implies a kind of hierarchy with political speech at the very top of the hierarchy because we're educating ourselves, as I mentioned, for self-government. But here, too, under this theory, government should keep its hands off of speech, and especially political speech. Now, these two theories have several things in common, but the one I want to mention in particular is that government suppression of speech must be avoided at all costs. Government should have no role under either theory. And even when government says it wants to facilitate free speech and to promote self-government, skepticism is appropriate. A very good example in First Amendment jurisprudence of that skepticism is campaign financing, where that skeptical approach has led to the erosion of the Buckley case from 30 or 40 years ago in connection with campaign financing. So those are some of the introductory comments I want to make with respect to theory as well. Now I want to get into some doctrine. And here I want to emphasize at the outset three important considerations in every First Amendment case. The what, which is the content of the communication, of the speech. The how, the medium through which the communication takes place. And finally, the forum, the where. Where does the communication take place? And the outcome in every free speech case depends upon these three considerations and their interplay. And remember or recall, the First Amendment is not absolute. So let's talk about the what at the outset, the content of speech. Not surprisingly, some speech gets maximum protection under First Amendment theory and jurisprudence, political and artistic expression. To show you how much protection political expression gets under the First Amendment, people can encourage others, let's say, to overthrow the government by force and violence. Sound familiar? Can encourage others to overthrow the government by force and violence, and even that is protected under the First Amendment unless there is the intent to bring that about imminently, and unless it is also likely that that's going to occur. But if even one of those conditions is not met, then that kind of speech is constitutionally protected. The idea is to provide maximum breathing space for free speech, to minimize chilling effect and self-censorship, and in real-world terms, government is supposed to wait as long as possible before it intervenes. only when you've got the intent and imminent unlawful conduct resulting. That's the famous Brandenburg decision from 1969, probably one of the most speech-protective Supreme Court decisions ever handed down. Some say it is the most speech-protective. Political speech can and does very often generate an audience. And that audience sometimes is in disagreement with what the speaker is saying. And sometimes that audience is about to threaten the speaker physically. What's the situation there? When can government intervene to protect the speaker from a hostile audience? And the Supreme Court has eventually adopted or bought into the approach of Justice Black dissenting in the Finer case, where he said, when you have a speaker who is riling up an audience and there's a possibility of violence from the audience directed at the speaker, the government has an affirmative duty to protect the speaker from the audience. I'll say that again because affirmative duties are rare in constitutional law. The government has an affirmative duty police have an affirmative duty to protect the speaker from the hostile audience. When does that affirmative duty get discharged? Well, when the police officers have made every reasonable effort to protect the speaker, but it turns out it's simply not going to work, then they can't stop the speaker. Otherwise, they've got to go after the audience. And that principle has some application in situations where the audience is not necessarily threatening physical violence against the speaker, but starts and begins to engage in what's called a heckler's veto, chanting, yelling, screaming, and the like. We've seen all too many examples of that, especially recently. In that situation, the government again has an affirmative duty to allow the speaker, to keep the speaker going. The hecklers themselves have their own free speech rights, interestingly enough, but they cannot disrupt. They cannot shut down the speaker. They cannot shout down the speaker either. And this has some significance in the university setting, and I'm sure we'll hear some things about that as well. But that's pretty speech protective as well, isn't it? Even falsehood is given some free speech protection. The famous New York Times v. Sullivan decision, if a person makes a defamatory comment about a public official or a public figure in connection with that public official's official behavior, for example, that public official can only recover for defamation if there is knowing or reckless falsehood. But ordinary falsehood, the common law of defamation has been changed by the Supreme Court since New York Times v. Sullivan, again to give the media, if you will, and all of us breathing room so we don't engage in self-censorship. There are, however, categories of unprotected speech. We're still talking about the what now, and one of those categories is true threats. If there is indeed a true threat that is unprotected by the First Amendment, it's in what I call First Amendment hell. You don't do anything other than rational basis review there. The First Amendment is inapplicable, and I'll just read to you what a true threat is. 3 attributes. A speaker knowingly makes a statement that would frighten or intimidate the potential victim with the threat of harm. Second, the speaker suggests that the threat will be carried out by him or co-conspirators. And third, a reasonable person would understand that this statement was meant to threaten. If these, according to the Supreme Court, if these three attributes are present, then this speech is unprotected by the First Amendment. Obscenity, there have been all too few, very few obscenity prosecutions in the last decades. Prosecutors have more important things to do, but when the definition of obscenity, remember, appeal to prurient interest, community standards, offensive by community standards, minimal redeeming social value. When those criteria are met, we're in an obscenity world, and obscenity is not protected by the First Amendment at all. Child pornography is utterly unprotected by the First Amendment. I think it may be the only example of communication which is unprotected by the First Amendment because of conduct that precedes it. And the conduct that precedes it is using children for child pornography purposes. And the theory is that when you go after the communication, the subsequent communication, the movies, the photos, and the like, if you can prosecute those, you are undercutting the illegal conduct itself, because obviously there's no First Amendment protection for getting children, abusing children sexually for movies or for photographs. Hate speech, a topic that has been discussed for quite a while. Hate speech is not its own First Amendment category. Hate speech is protected by the First Amendment. And what is hate speech? How is hate speech defined? It's defined as speech directed at a historically oppressed religious or racial minority with the intent to insult and demean. Now, despite the obvious harm that hate speech causes, both individually and socially, it still contains political ideas. And for that reason, among others, hate speech is covered by the First Amendment, depending upon the situation in which it does take place. Similarly, lewd and profane speech is covered by and protected by the First Amendment. Remember what I said earlier. The First Amendment has costs. The fact that hate speech is covered by, protected by the First Amendment, imposes costs on those who are the subjects of the hate speech, the objects of the hate speech, and perhaps the rest of us because of the degrading effect it has on social discourse. First Amendment has costs. All constitutional rights have costs, and the framers did that balancing a long time ago. So some general principles now from the what part of this. Government cannot discriminate against speech because it disagrees with that speech. Viewpoint discrimination is what's prohibited by the First Amendment. It also cannot exclude certain subjects from public discussion. Content discrimination for the most part. So as a practical takeaway, your speech can't be restricted by government because of what you say, even if it's controversial. However, counter-demonstrators have First Amendment rights of their own, and as I mentioned earlier, this is of particular significance in the university setting currently, especially with respect to public universities to whom the First Amendment applies. First Amendment doesn't apply to private universities as such, but there may be free speech norms that do and should apply to private universities.
Don't steal my thunder.
Oh. I've never stolen anybody's thunder.
Okay, phew.
So we're good. Now the how. The particular medium. Well, what do we have? We have speaking, we have writing, we have demonstrations, we have leafleting, we have sound trucks, or we used to, we have the internet. Different media, this is an important takeaway, different media have different characteristics, quite clearly. And the Supreme Court has been concerned that attempts to prohibit media, not content particularly or viewpoint, but attempts to prohibit media are really attempts to suppress speech. So it turns out that the government cannot prohibit leafleting on sidewalks or streets. And in part because that's how little people, quote unquote, get their ideas across. And the government and the Supreme Court is concerned that government may pick on the little guy and the media that the little guys use and try to stifle their expression. On the other hand, prohibitions against sound trucks may be constitutional, even on streets. Why is that? Because sound trucks have certain characteristics, don't they? They have certain characteristics that might interfere with your psychic well-being, if you will. For example, none of us would have a free speech problem with an ordinance that prohibited sound trucks, even for political purposes, with political noise, so to speak, between 10 o'clock at night and 6 o'clock in the morning. That is a reasonable time, place, and manner restriction, not directed at content. You should know, by the way, if you don't already, that the Internet as a medium of communication has been given considerable First Amendment protection from government regulation. Okay? So, general principles, special First Amendment protection for media that have historically been used by little people to get their messages out to others. There is judicial sensitivity to that. Practical takeaways from the how part of this, demonstrations, which are a combination of the spoken, the written sometimes, and conduct, are entitled to significant First Amendment protection. Note that there may be noise restrictions under local law. You can distribute leaflets and other literature on public sidewalks. You can approach pedestrians. These are some of the practical consequences of the Supreme Court's jurisprudence in this area. And finally, the where, the forum. Notice what's missing from my what, how, and where is the rock group called The Who. I couldn't fit them in. That's standing, but that's not part of my presentation. So what's the where all about? We're talking about streets and parks, traditional public forums, and the like. The where, the forum analysis is very complicated. What I'll be able to go through quickly is just the basics, because there are different free speech rules, believe it or not, for different kinds of public property. There is something called a traditional public forum. Streets, parks, and the like, where the government cannot absolutely prohibit all public meetings in traditional public forums. Why? Because these forums, streets and parks and the like, have been used for assembly and communication for, quote, time out of mind. There is a historical argument that buttresses the free speech principle that governments control over speech in traditional public forums is very severely limited. There is something called a designated public forum, and what that means is that this is government, that's government property, that the government voluntarily makes into a public forum. When the government does that to certain property, you can imagine that happening to an auditorium, right, owned by government. You can imagine that happening to certain kinds of other public property. Government says this is the equivalent of a traditional public forum, so the same rules apply there. Now, there is a lot of public property that is characterized as a non-public forum. And where there is a non-public forum, government can limit speakers and subjects. A good example of that, which may surprise you, is the town hall meeting. At a town hall meeting, not everybody gets unlimited time to say whatever he or she wants on any subject. So this is a non-public forum. The only rule for non-public fora is that government cannot discriminate on the basis of viewpoint, but it can limit subjects. Another, perhaps more mundane example, government can set up a theater in an auditorium and say, we are going to do only Shakespeare plays here. There's no constitutional problem with that, even though that is content regulation. Obviously, that is a non-public forum. I think my colleague Marty Mallon is going to talk about this a little bit, but I want to just advert to this here. There is no First Amendment right to demonstrate or even speak on private property where the owner objects. This would be a trespass. To put this another way, there is no First Amendment right of access to private property under the First Amendment. So, here are some general principles and some takeaways. Since even traditional public forums are used for other purposes, such as transportation, the movement of people, and since different groups realistically cannot demonstrate, for example, at the same time and in the same place, permit systems are constitutional. They have to be constitutional, so long as they amount to reasonable time, place, and manner regulations. Criteria must be set out in advance. The governmental decision maker must not have unfettered discretion, because otherwise there would be a prior restraint, and content and neutral and content and viewpoint neutrality are required. Let me go into the practical takeaways and then say some things that Justice Brandeis said better a long time ago. Demonstrations on streets and in parks may require licensing and the obtaining of a permit. But such regulations, as I've said, and I now repeat, must be content neutral and reasonable. If there is no permit given, people can stay on sidewalks, obey traffic and pedestrian signals, and must allow enough space for normal pedestrian traffic. Even if you don't get a permit, you can do that. Lawyers obviously have a major role in advising clients about engaging in political protests, for example, because these lawyers are often the bridge between the protesters and law enforcement. And that role occasionally creates ethics issues, because I don't think we're supposed to advise our clients to violate the law. I think we can advise them what the consequences can be or might be if they do violate the law. But that's something for a later discussion, perhaps. Let me conclude the favorite words for an audience. Let me conclude by reading a few things very quickly from Justice Brandeis's concurring opinion in Whitney v. California. Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. They believed that the final end of the state was to make men free to develop their faculties, and that in its government the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness, courage to be the secret of liberty. They believed that freedom to think as you will and as you speak, as you think, and to speak as you think are means indispensable to the discovery and spread of political truth, marketplace of ideas, that without free speech and assembly, discussion would be futile, that with them discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. And here is what I want to emphasize, because Justice Brennan gives us a beautiful concept of the duty of citizens in a democracy like ours. Public discussion is a political duty. This should be a fundamental principle of the American government. I thank you.